Hi, my name is Jerry Marcus from the law offices of Gerald Marcus. If you've been involved in a slip and fall accident or a trip and fall accident on somebody's property or inside of a supermarket or a mall or on any public property, you may have a case if you were injured. These are particularly difficult cases. They're almost always disputed by the landowner or the management company, again, whether it's a supermarket or a mall. These cases break down into simple elements. Number one, we have to prove that you were legally on somebody else's property and that you weren't trespassing. That's usually pretty easy. Number two, and one of the most important parts, is that we have to prove that there was a dangerous condition, that there was something there that caused you to slip and fall or trip and fall, that there was a defect or some hazard, whether it's a spill or some foreign substance on the floor. So assuming we have that dangerous condition, we're not out of the woods yet. We next need to go to the issue of notice. In California, the law tends to favor the landowner in a premises liability case, and we're required to prove that the landowner or property owner or management company had actual notice, that they knew of the existence of the dangerous condition. And they almost never admit that. The way that we kind of get around that, though, is the law also provides that if we could show the defendants had constructive knowledge, that they should have known of the condition. In other words, had they exercised reasonable care in the maintenance of their property, had they performed regular routine inspections and swept their property regularly, then they probably should have known of the existence. And generally, when we can prove that they didn't do that, they didn't have a sweep sheet or an inspection log, these are the types of things that you usually see on the back of a door in a restroom at a movie theater or in a restaurant. They're required to keep those. But if we could show that they're faulty or they don't have those at all, then we can prove that they should have known about the dangerous condition. And then we get into the issue of causation and the injuries. These are called premises liability cases. And again, they might be against a private property owner or a public entity, the city for a sidewalk case or at a public park, and they're somewhat complex. But if you've been involved in any kind of a slip and fall or trip and fall accident and you suffered injuries, please call me so that I can evaluate your case.